So this video is going to take us through the offence of unlawful act manslaughter, sometimes known as constructive manslaughter. Tends to be a more old-fashioned way of describing it. And this is a type of involuntary manslaughter, which is an offence, not to be confused with voluntary manslaughter. So the scenario that we're going to use is Alvin is throwing stones at passing cars. One of the stones goes through the open side window in Dawn's car and hits her on the head. She loses control of the car and hits a pedestrian, Keith, who is killed. So we're looking at Alvin's criminal responsibility for the death of Keith. So yes, you are absolutely right if you have said, I think there's an issue of transferred malice there, where your intended victim is not your eventual victim. Well done, good spot. That would be something you would absolutely consider, but that's not going to be the focus of this video. So we're just going to focus on the unlawful act manslaughter here. So, and we're going to use our state, explain, apply model. So first we're going to state that there must be an unlawful act, meaning it can't be a civil wrong, neither can it be an omission. And this is seen in the case of R and Lamb, in which there has to be an unlawful act. In that case, there was no unlawful act, and therefore there was no unlawful act manslaughter. Here we can see that the unlawful act is when Alvin commits a battery, he throws a stone at Dawn, he has the actus reus because he applies unlawful force. Note how I've used the legal definitions of assault, of battery there. So saying it's application of unlawful force, not he hits her on the head. We're then going to move on to say that the unlawful act must be dangerous. This is an objective test in church, what the reasonable man would term as dangerous. The harm need not be aimed at the victim, so as in Mitchell, the post office pusher. Physical harm must be intended, and it's not enough just to scare somebody, and you can compare the cases of Dawson and Watson. And remember, if the reasonable man knows, then the defendant is expected to know. So it's a lot to do with what you would see, and it's enough for the harm to be aimed at property, although it wasn't in this case. So in this case, the reasonable person would see that throwing a stone at somebody is going to expose somebody to a risk of harm. Doesn't matter whether Alvin foresaw the risk of death or whether the reasonable man would have Dawn in their contemplation, they would know that throwing stones is dangerous. The unlawful act must cause the death, so explaining factual and legal causation. But for Alvin throwing the stone at Dawn, Dawn wouldn't have lost control of the car and Keith would not have died. Legal causation, Alvin is the operative and substantial cause of Keith's death. If he hadn't thrown the stone, then none of it would have happened. And finally, our defendant must have the mens rea for their particular unlawful act. So there doesn't need to be any intention to cause harm or death, and this is explained in the case of Newbury and Jones, in which our defendant pushed a slab onto an oncoming train. Although they didn't foresee the risk of death, they did have the mens rea for the unlawful act, which in that case was criminal damage. And in our case, Alvin is probably reckless as to causing the battery, which is sufficient. Although it was not his aim or purpose, so it was not direct intent as in Mohan, or even virtually certain, as in oblique intent in Woolin, he would have seen the risk of hitting somebody by throwing stones and taken it anyway. And therefore we can conclude that Alvin is likely to be held liable for unlawful act manslaughter. So that is how you go about stating, explaining, applying the law of unlawful act manslaughter. On the dangerousness point, you would spend more time and more consideration thinking about the particular nature of the dangerous act. But remember, it's what the reasonable man would see. So if your defendant if your victim looks particularly vulnerable or fragile, then the reasonable man and therefore the defendant would know that scaring them, and just scaring them, is likely to be dangerous. So use your common sense on that one, and remember to tell the examiner where you got your ideas from and how you reached that conclusion.